Our next speaker is Lily Kravitz, who is a lawyer, who's the chairperson of the Clinical Ethics Committee at Maimonides at Jewish Eldercare, has a great deal of experience in dealing with family law, and has been a benefit to our committee for many, many years, and to the two centers. So I introduce Lily Kravitz.
The interesting fact about this case is that if the person was capable of giving consent, was totally capable, compos mentis as we say, then there would be no problem, because he or she, whatever the case may be, could grant consent to either having the treatment or not having the treatment. This case is one that we see all the time, and more, unfortunately, in law, because of, well, I'll say our aging community, because that's a reality of life. Our code, our civil code, is what guides us in determining what we can and cannot do. It's very much different from what the rabbi just discussed, because our code deals in great part with prolonging care. That it deals with it very well. Withdrawal of care is dealt with very, very poorly. Unfortunately, I have to take some time to read some of the articles from the code to you, because it speaks far more articulately than I could ever do. Our code, the first article in our code, deals with the fact that our civil code in Quebec, which is our governing law, is to be read with in harmony with our Charter of Human Rights, the famous charter brought to Canada by Pierre Elliott Trudeau. And our Charter of Human Rights clearly says that every human being possesses juridical personality, has a personality, and has the full enjoyment of his civil rights. Every person is fully capable of exercising those rights. Only in certain cases does the law provide for representation or assistance, and clearly that is the case in cases such as the one before us today. When a person cannot give enlightened consent, whether in whole or in part, he has the right to be represented by someone. Normally, that is done in our law by way of a written mandate that the person has prepared prior to his illness, or by way of an application to the court for what we call protective supervision. Many people will simply say an application for curatorship, but that's a real misnomer, because the application is one for protection of the person who can no longer protect himself. Our courts encourage treatment rather than encourage withholding of treatment. The prolongation of life is the rule, and the shortening of life is the exception. That's why when people come to me now to prepare mandates, and I recommend that all of you have mandates in anticipation of the time when you can no longer express your own wishes, I always tell them, think very clearly as to what you want to put in your mandate, because you have a right to write your mandate in such a way as you wish to, in the manner in which you want to be treated when and if you can no longer express your own wishes. And people have very often said to me, you know, if I can't do X, Y, or Z, then just pull the plug, where there isn't always a plug to pull. On the contrary, sometimes a plug to be put in, as we see in this case. So I really recommend to people now, think very long and hard as to what and how specific you want to be in writing your mandate. You have the right to do that, and you should really be doing exactly that. Because when mandates first came into our law in 1994, people would go to a lawyer or notary, and it was almost a form. The public curator's office was giving out forms, and they really said, as part of what we call the living will section of the mandate, that in the event that I can no longer care for myself, I do not want any heroics. Now, what is heroic to me may be totally different for someone else. So I think that everybody should, in the event of they're preparing their mandate, sit down with their notary or their lawyer, whoever's preparing it, and really discuss the matter in full, and not simply use the catch-all phrases. When we sit there in a lawyer or notary's office and we feel healthy and well, we say, if I can't do this, that, or the other thing, let me go. That's not always the case when we're actually in a hospital bed, and perhaps we have some satisfaction, and the code really deals with it. If you have your surroundings that you're comfortable with, family and friends who come to visit you, there is a reason perhaps that you would want to still be around. So I really urge you that when you do these mandates, that you think about it. In the absence of a mandate, what happens? Well, the law provides for the application for what we call protective supervision. And protective supervision for most people, unfortunately, because they're at a state where they can no longer make any decision whatsoever, particularly in the latter stages of Alzheimer's disease as a classic example, then a curator is appointed. A curator is appointed by the family, at least 5 members who actually come to court and give their advice to the court as to the naming of a person to be the curator. At that point in time, the curator has taken over and is responsible entirely for the person. The person who has a curator named no longer has any civil rights. They can't vote, they can't make decisions for themselves, including health decisions. And that's where we come to this point where a decision would be made by a curator or a mandatory being the person named in the mandate, to the nature of the treatment that the person will have. The courts have gone so far, and there's some case law that I've reviewed today, that even when a mandate has not been ratified, homologated by the court, and I won't go into that because it's not terribly important, but when in the absence of a judgment by the court on the mandate, if a mandate is specific enough and it hasn't been ratified by the court, the doctors in the hospital can still look at that mandate and say, what does this person really want? What were his wishes? And listen to the family and determine this is what this person would have wanted, depending on the type of life he led, his religious beliefs, the knowledge they have of the person and his view of life. And the courts will look at that. The important article that I really do want to read to you is, no person may be made to undergo care of any nature, whether for examination, specimen taking, removal of tissue, treatment of any other act except with his consent. And the mandate and the curatorship that I'm talking about is the substituted consent. When you can no longer give her consent, nobody can undergo any treatment unless they can give consent. As I said, if this person could give consent to the treatment at the beginning of my talk, then of course the treatment would be given. Since he can't give consent, then someone else has to give the consent or refuse the consent on his behalf, because he no longer can do it himself. And the law goes on to say, if the person concerned is incapable of giving or refusing his consent to care, a person authorized by law, a mandatory or a curator, may do so in his place. So the law is very, very clear and precise on it. A person who gives his consent to or refuses care for another person is bound to act in the sole interest of that person, taking into account as far as possible any wishes the latter may have expressed. So it doesn't even have to be in the mandate. It can be something that has been expressed to his wife, a significant other, during his lifetime when he was healthy. If he gives his consent, he shall ensure that this is extremely important, that the care is beneficial, notwithstanding the gravity and permanence of certain of its effects. In other words, a certain proportionality. If the treatment is going to be beneficial, then of course the courts will say, yes, you should grant this treatment. If it's not beneficial and may even result in his demise, then the courts will allow you to withhold the treatment. Although, after doing my research today, I found no cases where the courts ordered treatment to be withheld. On the contrary, all the cases dealt with treatment that was ordered for the benefit of the individual. In cases of emergency, again, as I said, the court deals very well with prolonging life, but not with withholding treatment. Consent to medical care is not required in case of emergency if the life of the person is in danger or his integrity is threatened and his consent cannot be obtained in due time. In the case of in the event of an emergency, the courts really and the law really deals with the fact that a person should be treated and not in a state where treatment has been withheld. So, as I said before, the law deals very well with treatment and not very well with withholding treatment. And there's no case law that I found on it. In an interesting case, the Court of Appeal of Quebec, and it was a case brought to the court by the public curator. The judgment of the Court of Appeal was very interesting and much more in tune with what the rabbi said. and I have to translate from the French to the English. The treatment that must be in the interest of the individual, obviously, and it must be the least constraining, the least aggressive, the least intrusive possible, taking into account the gravity, the seriousness of the illness, and the possibility of degeneration in the case at hand. And that was one of the very few cases where the courts really did say that treatment could be withheld. And that case has become a leading case, and the judges have all said that it must be dealt with and read very carefully when judgments are rendered. There is really no, and I can read many, many cases to which I won't do today, of course, but there are many, many cases where the judgments go back and forth because each case really is a cause d'espèce. The facts in each case are so different, and the wishes of the family are so different, and they all have to be taken into account. So while there are many judgments, and many judgments have made where treatment was ordered, it was very often in cases where someone had suffered from a psychiatric illness and refused to take their medication. There the courts have ordered the medication to be given, notwithstanding the person's wish to withhold the treatment for himself, because his consent was vitiated by the fact that he was mentally ill. And that would be 95% of the cases that I read, interestingly enough. It dealt very little with people with dementia or other situations of this kind, where the courts really do, insofar as possible, leave it to the family, the doctors, the social workers to come to a conclusion. Of course, if it's not possible, then the recourse of the individual and the hospital very often is to apply to the court for a ruling.